Hi, I'm Jennifer Novak. I'm an environmental lawyer representing California businesses and property owners in compliance matters, enforcement, and litigation. So today is part two of a discussion on penalties for environmental law and regulations violations. And I'm going to give you some food for thought on ways to reduce the dollar amount of penalties in environmental cases. So first, let's do a recap of some of the lessons of part one. Before you try to figure out whether you're being offered a fair deal to settle an enforcement matter, or if you're trying to negotiate lower penalties from a judge, you need to remember why there are penalties in the first place. They're imposed to make up for actual or perceived harm, as a deterrence for future behavior, and to make you an example to other businesses. Now, there are situations where penalties are set and there's really no negotiating room. But what we're talking about today are situations where there's a range of penalties or discretion as to the amount that can be imposed. So with that in mind, let's focus on a few things that could make a difference to the amount of penalties that your business has to pay. Number one, penalties are usually based upon an assumed number of violations and a perceived level of actual or threatened harm. So if you have documents or other evidence to rebut the number of violations, or we can show that the alleged violations don't rank high in terms of seriousness, that is one way to bring down the dollar amount. Number two is the issue of deterrence and using your business as an example to others, and whether a certain level of penalties is necessary to ensure that your business doesn't have future violations. Now, this is where good faith compliance can really matter. So being able to show that you're the kind of business that catches problems before they occur, or that you fix problems as soon as you're aware of them, and you're the kind of business that generally has no compliance problems, but there may have been some mistakes or one-time violations. Those can help demonstrate that you're not the kind of business that needs to be punished and lower penalties are warranted. Number three is that it may be possible to shift some costs away from being straight penalties into some other meaningful action. For example, some agencies will allow a business to invest in what we call a SEP, a supplemental environmental project. And sometimes that means a business agrees to fund a necessary study or education or in some other project to help mitigate environmental harms. And while this policy doesn't usually allow you to completely avoid penalties, a SEP can be used in lieu of a straight monetary payment. Number four is if you have some sort of legal leverage, use it if you can do so in good faith. Sometimes a business has good arguments as to why it shouldn't be subject to the amount of penalties or the number, or whether there's a dispute over how to interpret certain regulations. And you might be able to reach a more favorable deal if it helps all parties avoid additional litigation and the law is a little unsettled. In future videos, I'll go through a few examples of how we've used some of these strategies to help our clients mitigate the amount of penalties they've had to pay to settle environmental violations. In the meantime, if you have specific questions about how to avoid enforcement matters in the first place, or if you'd like some advice because you're already in an enforcement situation, check out our website at www.jfnovaclaw, or just reach out to us on our contacts page, and we'd love to hear from you.